Good morning, California. Good afternoon, the rest of America. My name is Mark Newberger, and I am not in California, but I'm coming to you from beautiful, sunny downtown Miami, Florida. But the good news is the rest of today's speakers are coming to you from California, and I will introduce them to you in just a moment. The topic today, of course, is California employment law. It all begins in California. The thought process here is that many of you may have operations in California, and for those of you who don't, you know that California oftentimes is the bellwether when it comes to employment law and employment trends, and therefore, even if you're not in California or your company's not in California, knowing what's going on there can be very valuable to you to see what's coming down the pike. And with that, I will introduce today's speakers. First, she would be the only female. It's Krista Cabrera, who's a partner in our San Diego office. I don't know if that's your right, my left, whatever. It's Caleb Burry, who's an associate in our Los Angeles office. And on the other side of Krista is Kevin Jackson, senior counsel in our San Diego office. Each of these three lawyers is well attuned and familiar with all of the legal trends in California. They regularly litigate in state and federal court in California. They even know what PAGA stands for if you don't, and are here today to share with us what's going on and what you need to know. Next slide. So just to give you a rundown of the agenda, Caleb is going to start us off with a discussion of policy and document updates, including handbooks. Kevin's going to talk about wage hour trends and developments. Krista is going to then focus on at least two new laws in California regarding restrictive covenants. We'll then come back to Caleb about workplace conduct. And finally, Kevin will wrap up with arbitration, and then we will take questions. So please keep questions in mind and put them in the chat as we go along. And with that, Caleb, take it away.
Thanks, Mark. So let's start with SB 616. Currently, employers are required to provide at least 3 days or 24 hours of paid sick leave. Starting on January 1st, 2024, that amount increases to 5 days or 40 hours. SB 616 also raises the cap employers can place on paid sick leave accrual from 6 days or 48 hours to 10 days or 80 hours. The law also extends existing procedural and anti-retaliation provisions to employees covered by a valid collective bargaining agreement. Those individuals previously were not covered under those provisions. When updating handbooks, it's important for employers to be mindful that these changes may result in the state law now being more generous than existing local sick leave ordinances. If the two laws differ in any way, employers should still follow the golden rule of applying whichever is more generous to employees. Speaking of local laws, many people were hoping the legislature would include an express preemption of the various local sick leave laws, thereby creating greater uniformity amongst the patchwork of sick leave laws in this state. Unfortunately, no reason to celebrate quite yet, while SB 616 does contain language regarding the partial preemption of local laws in very limited specific ways. An overwhelming majority of local laws are not inconsistent with state law on those specific topics. So it's not really having the intended effect that employers hoped for. Maybe in the future, we'll see. So with regard to SB 848, next slide, please. Thank you. Under this law, employers with 5 or more employees must provide employees who have completed at least 30 days of employment with 5 days of unpaid leave for a reproductive loss. It's important to remember this applies to non-birthing parents as well as birthing parents. It's also important to remember that this is separate from bereavement leave and leave under the California Family Rights Act. In fact, it differs from these other forms of leave in an important way. Documentation requests are not permitted with regard to verifying an employee's request for reproductive loss leave. Finally, employers are not obligated to provide more than 20 days of reproductive loss leave to eligible employees who experience multiple reproductive loss events in a single year. Okay, so with AB 2188, we're seeing an amendment to the Fair Employment and Housing Act, also known as the FEHA, to make it unlawful to discriminate against employees or applicants because they have engaged in off-duty cannabis use unless the individual seeks or holds one of a handful of exempted job positions. Specifically, this law exempts jobs that require federal clearance or background screening, any job that is statutorily subject to federal drug testing requirements, and certain building or construction trades. It's important for employers to remember that they must be careful with the type of drug tests that are used. Testing for psychoactive cannabis metabolites only. Non-psychoactive cannabis metabolites cannot be tested because that would be indicative of prior use. And the biggest takeaway from this law, potentially, is there's a new protected category under the FEHA for off-duty cannabis use. Failure to comply with AB 2188 then means that an employer may be subject to claims for discrimination, harassment, or retaliation on the basis of off-duty cannabis use. If a plaintiff were to succeed on these claims, we know that employers could be liable for damages in the form of future or lost wages, emotional distress, statutory penalties, and attorney's fees. SB 700 prohibits employers from requesting information from job applicants regarding their prior use of cannabis and prohibits employers from considering information regarding an individual's prior use of cannabis obtained through their criminal history, unless doing so is permitted under California's Fair Chance Act.
Caleb, one thing just as a practical takeaway on this, I've been telling clients just basically now think of it like alcohol. When you're testing for something like reasonable suspicion, you're testing blood alcohol levels. So you're testing for active impairment, as opposed to some tests that can figure out whether they used it weeks or even months ago. I think that's helping a lot of employers really put that into perspective about where we're at with cannabis in California.
Absolutely. Very great point. Thanks, Kevin. Next slide, please. So SB 553 creates a comprehensive set of new laws requiring employers to take actions aimed at preventing and responding to incidents of workplace violence as part of their existing injury and illness prevention plans or as a standalone policy. Under this new law, workplace violence is defined as any act of violence or threat of violence that occurs in a place of employment, including the threat or use of physical force against an employee or an incident involving a threat or use of a firearm or other dangerous weapon. Some important aspects about this would be that actual injury is not required, so theoretically, a verbal threat over the phone would suffice. Also important to mention that lawful acts of self-defense are not included in this definition of workplace violence. This law comes with a lot of requirements. Amongst them are that employees will need to be trained on the new policy going forward. We've listed here several examples of some of the requirements for the Workplace Violence Prevention Plan. This is only a partial list, it's not exhaustive. There are roughly 12 enumerated requirements for workplace violence prevention plans in the future. Employers will also be required to maintain detailed logs regarding workplace violence incidents, among other forms of required documentation. Record-keeping requirements also range from 1 to 5 years, depending on the type of document. The legislature has given employers until July 1st, 2024 to prepare for this law. It is very comprehensive, so we suggest consulting with your counsel and getting in shape for July 1st, 2024. Okay, so SB 428 is a counterpart to the SB 553, which amends existing law regarding temporary restraining orders. Existing law regarding TROs authorize any employer whose employee has suffered an unlawful violence or a credible threat of violence from any individual at a workplace to seek a TRO on behalf of the employee. SB 428 will result in 4 specific amendments to the existing law, which will greatly expand the ability for employees to obtain TROs in the employment context. Next slide, please. So in the Rains versus U.S. HealthWorks Medical Group case, the court addressed the question of whether an employer's business entity agent, in this case, a third party that carried out pre-employment medical screenings for the employer, can be held directly liable under the FEHA for employment discrimination. The court held that an employer's business entity agent can be held directly liable under the FEHA for employment discrimination in appropriate circumstances when the agent has at least 5 employees and carries out FEHA-regulated activities on behalf of the employer. As a result of this decision, it's important to remember for employers, carefully review your indemnification provisions and agreements with vendors. Next slide. Thank you. And Kevin's going to talk to you about some wage and hour issues coming up. Thanks, Kevin.
Thanks, Caleb. Before we get into the new laws, some of the things that Caleb touched on have some wage and hour implications that I wanted to point out, particularly the paid sick leave requirement. So this is nothing new, but it's a good reminder that in California, things like paid sick leave have to be paid out at the employee's regular rate of pay, which is a different calculation than the straight hourly rate that a typical wage earner receives. So that can include things like non-discretionary bonuses and shift premiums. And it's important to keep in mind things like paid sick leave require this, because what we're seeing in the wage and hour litigation and class action context now are increased claims that are based on these really small nuances of the law. So it's not that the employer failed to pay paid sick leave or provided to employees, but that it paid it out at $15 an hour instead of $15.40 an hour. And so it's really important with these new updates that we keep some of the ripple effects in mind, and it's a good opportunity to review those types of payroll practices. All right, first slide, please, Mark. All right, every year it seems like we have a new minimum wage in California. That trend is continuing this year. This year, what we're seeing is the regular minimum wage increase for all workers according to the schedule that's been in place for the last several years. So now all workers in California starting January 1 will receive at least $16 an hour in minimum wage. And the real important takeaway for a lot of companies here is that triggers the new minimum salary requirement for exempt employees. So we're up to $66,560 for that now. So we see this all the time every year where there's a minimum wage increase, and sometimes employers are failing to raise that floor salary for their exempt workforce, which can lead to losing the exempt status, which has major implications for overtime and meal and rest periods and the types of issues that individuals are exempt from when they are receiving the appropriate salary and are otherwise qualified for the exemption. This year, we have 2 specific industries that are raising the minimum wage due to extensive lobbying efforts. So one is the fast food workers minimum wage is going up to $20 an hour, April 1st, 2024. So we'll probably see an increase in the price of Big Macs coming soon. Then for healthcare workers, we have new minimum wage schedules starting next year, and for the next several years, increasing up to $25 an hour. So big increase to the minimum wage for healthcare workers. Next slide, please. All right, time rounding. So this is an area that we've continued to see a lot of activity in the wage and hour class action context. Time rounding as a general matter, as a practice whereby instead of tracking an employee's specific time that they're clocking in, you'll round to the nearest. Often we see quarter hour is a typical one. So if you clock in, let's say at 7:57, the system would log you in at 8 a.m. Or if you log in at 8:02, it tracks you as logging in at 8 a.m. For many years, this type of timekeeping practice was considered convenient. But what we're seeing in the legal side of it now is moving more and more away from courts approving of such practices. They've been generally considered okay so long as they're fair and neutral and ultimately don't result in employees losing on compensation over time. However, with really the rapid rise of timekeeping software and technology, where really every employee can clock in on their phone the second they badge swipe, anything like that, courts are becoming increasingly strict in their way that they're scrutinizing these policies, and they're becoming harder and harder to defend. So one case that's up on appeal to the California Supreme Court, another case that came out of the Court of Appeal level that are basically backing off and saying these practices are no longer considered lawful because we have the technology to track time. My advice to clients is just track the time. Even if it's inconvenient, it usually is not as inconvenient as you think. And the risk is really great. These cases are very expensive to defend. They're very data heavy, require a lot of expert analysis. And so now, unless there's a very, very good business reason, I would really caution against using time running practices. And if you do, I would consult with counsel and figure out how to do it in a way that is most effective and is going to have you on the right side of ensuring that there's never a detriment to employees. Next slide, please. All right, this is a COVID era ruling that came out of the Ninth Circuit earlier this year. So what happens at the end of employment in California? We all know that you have to pay all accrued wages, including PTO and vacation time. When COVID resulted in unprecedented, government issued shutdowns and stay-at-home orders, there was a lot of confusion, as many can remember, of how to deal with all of these various employment laws that don't quite make sense in that context. A lot of companies, including Hilton, had laid off many employees or furloughed them for a temporary period of time because nobody knew if these things were going to, 2 weeks to flatten the curve, right? So a lot of companies thought we'll be bringing people back in a few weeks and we'll go on business as usual. We all know how that went. And so a dispute came up where employees alleged that when you laid us off, even though it was a furlough for a temporary period of time, that triggered California's what are called the prompt payment obligations in the labor code, which you essentially treat like a termination. And the Ninth Circuit said they were supposed to have been paid at the outset of the temporary furlough, and that resulted in extensive waiting time penalties, which can be steep. It's up to 30 days for 30 days wages for each day that an employee is not paid all time owed. So that provided pretty clear case law on the issue now, where for really a furlough or a layoff, even if it is for potentially temporary but unknown duration, just treat it like a termination and pay it out. And unfortunately, we appreciate there are financial considerations and budgetary considerations when you're dealing with situations like this, and it might be better to keep those on the books. But the Ninth Circuit is telling us that's not the right way to do it. We need to pay it out and treat it like a termination. And last slide, Mark. Another COVID era issue that came out is working from home, and it's obviously surviving COVID. But in general, in California, employers have an obligation to reimburse employees for any business expenses they incur. So this is really simple when you're dealing with mileage. Let's say I have to drive to meet a client and drive back. That's considered a reimbursable expense. But what happens when you deal with expenses that are not quite so clearly tied to the actual job that you're performing? So one area we've seen this come up prior to COVID is the infrequent but somewhat regular use of employee cell phones, right? People often text during the workplace and during the workday. Managers might text a group of employees to provide assignments. This is only taking a few seconds, maybe a few texts here and there. Those are things that the courts in California are saying you have to provide reimbursement for employees. So now we go a step further and we start talking about work from home arrangements. In the case that came out in California, Tide versus IBM, this was a company practice that had people working from home early in COVID when there were shutdown orders. And it was essentially not that the company was wanting people to work from home, but in order to comply with a government order, they had people working remotely. And the company argued these aren't expenses that we're passing off to employees. This is something that we're not requiring as the government. The court disagreed and essentially didn't say, of course, what exactly you have to pay for. But when these are, expenses that are incurred in order for the employee to do their work, they need to be reimbursed. And in this case, even though IBM was just trying to comply with the government shutdown orders, nonetheless, it was still considered an operating cost that needed to be reimbursed. Essentially, that they were passing off their cost of continuing to do business under the new regulatory guidelines onto employees rather than reimbursing them. There's still some open questions, but really, when the company is either having people work remotely as a general matter, we're advertising it as a remote position. That's part of the benefit of the job. Those are pretty clear situations where an employee needs to be provided some sufficient amount of stipend or reimbursement for reasonable home office expenses. So that doesn't mean that they can go buy a $10,000 couch and set that up in their home office. What that means is, estimating reasonable costs for home internet and office supplies and, a basic workstation. Those are the type of expenses we're talking about. And so it becomes important to have clear policies in place, identifying what's reasonable. You might even work with some preferred vendors and allow employees to order things and obtain some cost savings there. Where this starts getting a little bit murkier is when you're dealing with hybrid work arrangements or quote unquote voluntary work from home. I think there's still a pretty good case to be made where if our preference is for you to work in the office and you have an office and we're providing everything you need to work here, but as a benefit to you, you can work a day or two a week from home. We still think that's a pretty good situation where you don't have to then incur the additional cost of essentially providing a second workstation as a matter of convenience. But this is where it becomes more important to have clear documentation and clear communication with employees so that everybody understands the arrangement. And I think with that, we are moving on to probably the most exciting topic that everybody wants to hear about, which is restrictive covenants in California. Take it away, Krista. Oh, you're still on mute.
Hi, sorry. This is the topic of the day. I cannot tell you how many emails and phone calls, all quite frantic, I've received about the 2 new restrictive covenant laws. And let me just preface this by saying California is just doing what California does. None of this is a big surprise to those of us who practice in California. And a lot, I will say, 99% of these 2 new laws is really just reiterating what the courts are already doing with restrictive covenants in California. There's a little gray area where things get dicey and certain interpretations of these laws could have potentially far-reaching impacts. That's going to be for the courts to decide, but let's talk about them. All right, we can go to the next slide. The first of the 2 new restrictive covenant laws is SB 699. Before we get into the law, I think it's really important to look at the preamble because this tells us why the legislature has put these 2 new laws in place. Really, what the fairly lengthy preamble tells us is California is not okay with the concept of employers having California employees sign non-competes that the employer knows are not enforceable, but puts in place in hopes of some sort of deterrent effect. And this is fairly commonly done, right? I know I can't have a non-compete in California, but I'm going to put one in the agreement anyways, just so that the employee thinks there's a non-compete and doesn't compete. If there's ever litigation, we won't try to enforce it, but we're going to put it in there anyways. That's really what these laws are aimed at. You can't do it. Another important thing to keep in mind about these laws is that they are talking about other states as well, primarily in the context of if you're an employee in another state and you come to California, California law now governs your employment, not the law of this other state. Now, the reason the legislature is so concerned about this is because it is found that just having non-competes in place at all, even if they're known to be unenforceable, creates a chilling effect on mobility. California cares a lot about employee mobility. And there have been all kinds of studies that shows lack of mobility stifles economic development and can tend to suppress wages, which exacerbate things like gender and race pay gaps. And finally, again, California's public policy against non-competes trumps every other state's law. Important also to remember the exceptions that exist still exist. So the big exception for the sales of businesses, right? I am an owner of a business. I sell the business. I sell the goodwill of the business. A non-compete is enforceable in that context. It always has been. It continues to be. These laws do not change the exceptions. Okay, we can go to the next slide. So what does 699, SB 699 actually say? Well, it prohibits employers from trying to enforce non-competes regardless of where and when the non-compete was signed. Now, clearly, this applies where I threw in this slide a Texas example. You can use Florida, you can use any state that has pretty employer-friendly laws regarding non-competes. Let's say Texas employee works for a Texas company, signs a non-compete that's totally enforceable in Texas. Employment ends. Let's say it's a 3-year post-employment non-compete. Employee moves to California, takes a job in California that violates that non-compete. It's in the same business. It's in a location that's covered by the non-compete. What this law says, and this is no surprise to me, is that once that person, that employee is in California, California law governs that employee's employment, and that Texas non-compete will not be enforced in California. Now, what's worrying people about this language, right? It says, regardless of where and when the contract was signed, if it doesn't comply with California law, it's unenforceable. What about the reverse situation? Does this mean that a company in California cannot have an employee in Texas sign a Texas non-compete? Because technical reading of the statute, it doesn't matter where or when the agreement is signed. Looking at the preamble as we just did, I don't think that's what this is meant to apply to. The preamble specifically says California has a strong interest in employee mobility in California. I don't know how California can dictate what happens in Texas or Florida or anywhere else. There are huge constitutional issues there, but a technical reading of the statute would suggest that is the case. So time is really going to tell in terms of what this, no matter where or when it was signed, language truly means and how it will be interpreted by the courts. It also says an employer shall not enter into a contract with an employee or prospective employee with an unenforceable non-compete. Again, that speaks to this issue of employers are putting these in non-competes in agreements knowing they're unenforceable. You cannot do that anymore. If you do that, the former, current, or prospective employee can sue. The employee has a private right of action, can seek damages, can get injunctive relief, and importantly, the employee gets their attorney's fees. So that's a new rub that employers have not been faced with in the past. Okay, we can go to the next slide. The next of the two new non-compete laws is AB 1076. This codifies a case that already exists. So again, not really big news, that says that voids the application of any non-compete in an employment context, regardless of how narrowly tailored that non-compete is. You just can't have one. Narrow tailoring does not work. And we've always told our clients, another thing you need to realize is California courts, as a general proposition, will not blue line. So again, you don't want to put this provision in an agreement, even though you know it's unenforceable, and have, a caveat saying, oh, if it's not enforceable, court, just take that out, but leave everything else. California courts won't do that. It also says it is unlawful to include an unenforceable non-compete clause in a contract, or to require an employee to sign an unenforceable non-compete clause. Again, you can't have that preventative clause there at all. This is a big part of this law that people are very alarmed about. If you have in place an unenforceable non-compete, you need to give notice to any employee subject to that non-compete that this provision is void or this agreement is void. It's got to be a written, individualized communication. It's got to be sent to the employee to their last known address and their email address. And for former employees, this needs to go out to those employees who worked for you anytime after January 1st, 2022. So that's a really important thing to keep in mind, this notice provision. Okay.
Krista, let me ask you a question that actually encompasses a number of questions that have been in the chat. And that is the employee moves from Texas where they had a non-compete, they moved to California. I'm guessing the answer is give them a new agreement in California that doesn't have a non-compete, but otherwise complies with things like confidentiality, perhaps assignment of inventions, so you don't risk the enforceability of the entire agreement. Is that right?
So, yeah, I mean, I think if we're looking at this as the example I gave you all, I envisioned an employer in Texas, the employment ends, new employer in California. The new employer in California absolutely is going to want that employee to sign like a PIIA, a CIIA, whatever you're going to call it, but an agreement that protects trade secrets, confidential information, proprietary information, and inventions. Absolutely, that's all enforceable, and you definitely want that with your California employees. You just can't have a non-compete or a non-solicit.
Right. So if they move within the same company and they had a Texas enforceable
new agreement,
non-compete,
yes.
By keeping that agreement and not changing it to comply with California, you risk the enforceability of all the other provisions, correct?
And you break the law. You cannot keep that in place. If the employee moves from Texas to California, you've got to give that employee a new agreement. Yes.
Okay, thanks. That should answer a number of questions in the chat.
Great.
Who's up next?
That's me. Hi, everyone. If we can go to the next slide, please. Thank you. So for SB 497, which is also referred to as the Equal Pay and Anti-Retaliation Act, essentially it makes it easier for employees to bring retaliation claims by amending 3 sections of the Labor Code to create a rebuttable presumption of retaliation for employees who experience an adverse employment action, such as termination or demotion, within 90 days of engaging in certain wage-related activities protected under the Labor Code or California's Equal Pay Act. Some examples of that would be filing a wage complaint with a labor commissioner, engaging in whistleblower activity, or bringing a PAGA action for alleged unpaid wages. Or class action claims for alleged unpaid wages as well. So that's not the end of the story, though. It's a rebuttable presumption. So the burden shifting still applies. In response to the rebuttable presumption, an employer can articulate a legitimate non-retaliatory reason for the alleged adverse employment action. And if the employer does so, the employee must demonstrate that despite the non-retaliatory justification, the adverse employment action was nonetheless retaliatory in nature. SB 497 also expands the maximum civil penalties for whistleblower retaliation from $10,000 per violation to $10,000 per employee for each violation, which essentially means that employers can now be subject to multiple civil penalties for a single violation. Next slide. In the case of Groff versus DeJoy, the U.S. Supreme Court addressed the duty to accommodate an employer's religious beliefs. Employers have a general duty to accommodate an employee's religious beliefs unless the employer can show that doing so would constitute an undue hardship. In a unanimous decision, the High Court heightened the burden on employers to defend against failure to accommodate claims, holding that undue hardship is shown when a burden is substantial in the overall context of an employer's business, and that an employer must show that the burden of granting an accommodation would result in substantial increased costs in relation to the conduct of its particular business. While this case involves claims under Title VII of the Civil Rights Act of 1964, we can be certain this ruling, which, like I said before, involves a heightened version of the undue hardship standard, will be used by plaintiffs' attorneys here in California in the context of California's Fair Employment and Housing Act. Next slide. Widely considered to be one of the ripple effects of the Me Too movement, the California legislature passed AB 933, which was signed into law and intends to protect sexual harassment plaintiffs and encourage them to bring harassment claims without fear of inviting further litigation against them from their accused harassers. The risk of being subject to attorney's fees, treble damages, and punitive damages will make people think twice, essentially, about whether to pursue a defamation claim, even in cases where someone has been wrongfully accused of sexual harassment or assault. Next slide. In Sharp versus SNS Activewear, 8 former employees, including 7 women and 1 man, alleged that the company permitted managers and employees to play sexually graphic, violently misogynistic music throughout its warehouse. The Ninth Circuit reversed the district court's dismissal, holding that such conduct did constitute sexual harassment and created a hostile work environment under Title VII. Considering the Ninth Circuit's ruling, employers should generally prohibit employees from playing explicit and/or offensive music or other media such as social media clips, TikTok videos, or the like in the workplace. And this is true even if most employees do not find something offensive or complain about it, because under the Ninth Circuit's reasoning, it only takes one offended employee to find the existence of a hostile work environment. And Kevin will talk to us about arbitration.
Right. Sort of on the one spectrum of fun with, playing explicit music in the workplace leading to sexual harassment lawsuits, we have arbitration, which is equally as sexy of a topic, particularly at the Supreme Court level the last couple of years. So, as many of you know, if you've been in California long enough, it's only a matter of time before you start dealing with wage and hour lawsuits brought as a group, whether that's a FLSA action, class action, or what we call PAGA, Private Attorneys General Act, which not only created a procedural mechanism for bringing claims for wages on behalf of a large group of employees, but also created a lot of penalties. So us crafty employment attorneys have been spending decades trying to help you avoid these. That has largely been accomplished through the use of arbitration agreements, which have received blessing by the United States Supreme Court in a number of big cases over the last couple of decades, basically upholding the federal policy behind the Federal Arbitration Act, and allowing employers to utilize class action waivers in the context of arbitration agreements that are required as a condition of employment. PAGA came along in 2004, and we thought, aha, we can just add PAGA waivers, just like class action waivers. Well, this is California, and PAGA is a whole different beast. And what we've seen is some oscillation in terms of the enforceability of those waivers. We have pretty clear ground now after a couple of big cases. I'm sure anybody who's vaguely familiar with anything that I've been talking about for the last minute probably heard about this case called Viking River that came out of the United States Supreme Court last year, which was sort of a mixed bag. It essentially upheld as a sort of academic matter the idea that an employer can have a PAGA waiver and an employment arbitration agreement, but they kind of cut, split hairs a bit and said what that means is that you can require an employee to arbitrate an individual PAGA claim in arbitration. And under the Supreme Court's interpretation of California law, they said that once an employee does that, they no longer have standing to go back into court and represent others in a PAGA representative action. But they said and left the door wide open, inviting California to clarify what actual standing meant under California law. California Supreme Court did that this past summer in a case called Uber versus Adolph, which essentially gutted all the benefits of Viking River and said, if you're an employee who has an arbitration agreement with a PAGA waiver, what that means is you can go to arbitration, arbitrate your individual PAGA claim, and then once that's done, you still have standing to go back and bring a representative claim in court. So what's the takeaway of this? Well, there's a couple of things. One, your wage and hour compliance is as important as ever. If you haven't had a good audit of your wage and hour practices, I highly suggest you do it, because PAGA creates really, really steep penalties or very ticky-tacky violations. And it's very out of proportion to what the actual harm or damage might actually be. And so with, the ultimate takeaway of Uber v. Adolph is PAGA cases are not going away. You can't get around them just by PAGA waivers. We can slow them down. We can drag things out. We can try to pursue a more favorable forum in arbitration, hopefully get a ruling that we didn't violate the law, and then try to use that in court. But that sounds like a lot of legal work and a lot of expense to get there. So ultimately, these PAGA claims really aren't going away. So compliance is still your best tool, right? Prevention is still the best medicine. On a more practical, immediate front, it's also, if you have arbitration agreements with wholesale PAGA waivers, they need to be modified to make it clear that what is actually happening is you're waiving your individual PAGA claim in court. If this all sounds rather academic, it really is. But ultimately, the takeaway is do your best to comply with the wage and hour law, update those arbitration agreements, and make sure they comply with the protocol that's been outlined by the California Supreme Court. Next slide, please. All right, and the most creatively named case of the year, we have Doe versus Superior Court. This is, again, California is very, very hostile towards arbitration agreements in the employment context, in the consumer context, but they're constantly butting heads with federal law that says arbitration is a preferred federal policy of dispute resolution. So California is finding a lot of little ways to chip away at that. Well, one thing they've done is make the timing of arbitration fees about as material of a term as you can find in these agreements, because the consequence for failing to pay your arbitration fees on time is that you waived arbitration altogether. So what this means in the employment context is employers, as a general matter, have to pay 100% of the cost of arbitration. So the employee files an arbitration demand, you get an invoice from the arbitration service that says payment is due in 30 days. So if I get this on December 1st, payment is due within 30 days by the end of the month. Well, what this case recently came out and said is, even if you send payment by check several days in advance of the deadline, but the arbitration service doesn't get it until the 31st day or the 32nd day, you have waived your right to arbitration. And that's a pretty severe consequence. And so, again, if you have arbitration agreements with your employees, you have to make sure that you're always above the board and complying with even the most, stricter requirements when it comes to things like initiating arbitration, timing of payment, and things like that. Anything that might be perceived as, a material violation is potentially going to, risk a waiver of arbitration entirely. So strict compliance is super important. Next slide, please. All right, here is another law that is very, very antithetical to the purpose of arbitration in general, which is typically in arbitration, if the employee files a lawsuit and they won't agree to arbitrate, we have to file something called a motion to compel arbitration, which is saying, hey, court, this guy signed an arbitration agreement, order him to go resolve his dispute that way. We don't belong here. The court says we agree, or we disagree. In cases where they disagree, the employer has the immediate right to appeal that ruling. If anybody's ever been caught up in appeals before, it can take years to get them resolved. And so what that would mean is that Once you appeal, typically you can't continue litigating in court for the next year or two while the appeal is getting resolved. That would sort of defeat the entire purpose of arbitration. California probably agrees with that and says, we don't care. So now there is no longer an automatic stay. This really isn't important for you on a day-to-day basis in terms of your HR teams or your legal policies, but it's just something to be mindful of in the bigger context of arbitration, which is California is continuing to chip away at, what has essentially been held as sacred in California and federal law in general, which is the ability to have arbitration agreements. So this is likely to be challenged. It's probably preempted by the Federal Arbitration Act, but we are unlikely to see any rulings on this for several years. So it's just really important if and when you get into litigation, you have somebody who understands these various nuances with arbitration. Make sure that you're complying with all of the requirements and understand now for issues like this that you're pursuing all the remedies you have, like moving for a stay instead of having one be issued automatically. And with that, I think we can turn to questions for our last 5 or 10 minutes here.
Okay, it's question time. Krista, you kept talking about bans on non-competes. Does that also apply to non-solicits of employees and non-solicits of customers?
Great questions, and the answer, sadly, is yes. California treats non-solicits of customers and non-solicits of employees just like non-competes. They are considered one and the same.
Caleb, I think this is for you. For sick leave, you have to have 5 or more employees. Is that in California or everywhere?
So the California paid sick leave law actually applies to all employers regardless of size. There is no small employer carve out.
Okay. We have time for more questions, so please throw them in the chat room. One that came in that I'm actually going to handle because I am co-chair of Foley and Lardner's Cannabis Industry Team Practice. And the question was, for cannabis, are there now tests that measure current impairment like those that exist for alcohol? So the more typical tests for marijuana, which are urine or hair, do not test or measure current impairment. In fact, they don't even measure levels of THC in the bloodstream. As I forget who talked about it, Caleb, they talk about metabolites, the leftover byproduct after your body processes the active ingredient of THC. Myself and my colleagues who practice in this area frequently look at what's out in the marketplace to measure current impairment. And we haven't seen any exact scientific tests. We've heard companies are working on them. So in terms of an instant test where you could put a drop of blood or urine or some other body sample and say, yes, they're currently impaired due to cannabis or THC, we haven't seen it. If they're out there, we don't know about it. However, one of the things I've been advocating for is other measures of impairment that have no impact on chemicals. If any of you have ever been pulled over by a state trooper and suspected of a DUI, you are asked to get out of the car and perform certain physical maneuvers. Walk on a line, close your eyes, touch your nose. These are scientific tests based to measure impairment that are admissible in a court of law for a criminal conviction of DUI. They can similarly be used in the private sector where you're not held to a criminal standard to measure impairment, but you have to train people in your workplace to do it, just like the police train them. And there are courses out there that will train your employees how to measure current impairment, not through a chemical or biological analysis, but through a physical analysis. And whether they're impaired from alcohol, cocaine, marijuana, psilocybin, as an employer, you don't care. They're impaired and they shouldn't be working there. So the question pops up is, do you recommend employers simply stop testing for marijuana? Well, in California and some other states, if you're going to be using a metabolite test, the answer is yes, because it's not going to give you any information you can use. Some other states like New York, New Jersey have also posed similar bans on testing because it's only measuring past use. And if the state has legalized recreational use, so I go home on Saturday, I smoke a joint or I pop some gummies, and I come into work on Monday, I'm going to test positive, but that does not mean that I'm impaired psychologically or physically from the use of cannabis. We don't have any other questions in the chat room. Does anybody of the three speakers have an additional point or two that they would like to make?
I will just say, you know, if you've got employees in California, this is the time to update your handbooks. Not only do a lot of these laws, as Caleb mentioned at the outset, require updates to policies, but oftentimes you'll look at your handbook, you realize, oh shoot, I didn't even update it last year. So you may have a couple years worth of policies you need updated in California.
And to help you with that, our three speakers each year put together a California new law newsletter. And each of you, by virtue of your patience of sitting through this presentation today, will get a copy. Some of you asked, will the slides be available? We have something better. This newsletter that you're going to get is more detailed and more robust. And everybody who signed up for today's program will receive one from Liz sometime following the program. Another question. Do the new sick leave laws require any changes to accrual schedules? Can the leave be front loaded?
Yeah, so it does require changes to accrual schedules. In terms of, well, I should correct that. In terms of whether the accrual schedule is on a calendar basis or on a beginning of employment basis, that does not change. That remains the same. With regard to the other part of the question regarding can the sick leave be front loaded? Absolutely yes. So sick leave can still be front loaded. The amount of sick leave provided to an employee on an annual basis has changed. So like I said before, 40 hours or 5 days of paid sick leave, and that can be front loaded still.
Krista, we have one more on the whole non-compete issue. Is the impact of an unenforceable clause to limit severability limited to non-compete, non-solicit, or does that apply to any unenforceable clause in the contract writ large? So if I'm correct in understanding, a prohibited non-compete or non-solicit invalidates the entire agreement, not just the non-compete. It invalidates your confidentiality provision, your arbitration provision, your assignment of inventions provision, correct?
Yes, potentially, yes. And keep in mind also, it's not just because that was always the case. It's nothing new about that. That was always the case. The bigger issue is just having it in the agreement. Beyond invalidating the agreement is unlawful. So that means you could potentially be subject to a claim under California's, it's called Business and Professions Code, Section 17200. It's a competitive unlawful conduct prohibition. You're going to be responsible for attorney's fees, potential actual damages, etc. So again, you just don't want these in contracts at all. It goes beyond the contract being invalid. It becomes an unlawful act to have it in the contract.
So if I give a new employee in California an agreement that has no non-compete and no non-solicit, but it has some other clause that's determined to be unenforceable, will the court blue pencil that, or is the entire agreement unenforceable?
I mean, that goes beyond the scope of non-compete. So potentially that could be blue penciled. Sure. It's not that California doesn't blue pencil as a matter of law or practice. It's that blue penciling doesn't apply when you've put an unenforceable non-compete in an agreement.
And I think this is going to be our last one. Are you sure confidentiality provision, but does a non-enforceable confidentiality provision, for example, invalidate the entire agreement? And I guess I think you're saying
there's no such thing. Sorry to interrupt, but I know we're tight on time. There's no such thing as, I guess there always could be such thing, but as a general rule, and confidentiality provision, right? That's a provision saying in the workplace, you will receive and be privy to confidential information. Don't share that information without permission. That is allowed. So I don't see a world in which that is deemed unenforceable. What could happen is information a company says is confidential, a court could later say that's not confidential. Everybody knows that. That doesn't make it unenforceable. That's just an interpretation of what is or isn't confidential. And again, you can have a confidentiality provision in a contract, no problem. What you can't have is a provision saying, you won't go work for a competitor for 3 years after working for us. You won't solicit after you leave our employment, you won't solicit our customers. After you leave our employment, you won't solicit our employees. Those 3 things are what you're not allowed to do. But a confidentiality provision, whether a company has, mislabeled a document as confidential or not, that's not going to be a problem here.
Hey, we have a good one here. This is a unique question. Okay, if you have to reimburse employees who use cell phones, but you tell employees don't use your cell phone on a job, it's not necessary. But then they hit a 2-factor authentication website, much like we have at Foley, right? Is that a de minimis use, or do you have to reimburse it if there's only occasional, 6-digit code sent to your text so you can log on to something?
Yeah, I'll field this one. I would say there is no such thing as de minimis when it comes to employee expenses in California. Even that concept for de minimis when it comes to things like booting up your computer are becoming more and more frowned upon. And so if it's something that they're required to do, even if that requirement is because of some third-party vendor, so that they can access systems that are on our, that are on our servers so that they can do their job, I'd say you need to find a way to provide some reimbursement. Now, if it is truly that is all they are using it for, you could probably add a very small stipend every month and have them sign some document. I would just document it. And this could be as minimal as $5 or $10 a month if that's truly it. I mean, I would look for solutions that require them not to use it at all, because they really shouldn't have to authenticate, something using in their own personal device anyway. If hopefully there's a way we can beef up security and they can just use their company provided equipment. But that's the type of thing that, we see these things come up, and we would just try to work with you on identifying, a practical solution that we can ultimately defend if this ever comes up in a class action. So that's kind of how we look at it and try to fashion something that's going to be, minimally burdensome from a cost perspective and an administrative perspective, but also buttons you up to be able to defend against a claim for failure to reimburse.
Final question of the day. Oh,
yes,
go ahead, Krista.
I just want to say, I see a couple things in the chat that I want to quickly address. We are now over, so we really have to say, just shoot us an email if you want to talk more. But I see the question, is it really clear in California that non-solicited employees are not committed? I thought it was a bit of a gray area. I could spend an hour on this. Non-solicited employees, there is an argument based on the first case that came out about 2 years ago that for the first time told us you can't have a non-solicited employees. It is considered a non-compete. There is an argument that that case is really fact specific, and that non-solicits of employees should not be treated as non-competes. However, we've had several courts since that case came out say that case says non-solicits of employees are non-competes and they are not allowed. So yes, it's grayer than non-solicits of clients for sure, but the case law has really gone the way of treating non-solicits of employees as non-competes. And is a customer list confidential? I see that is like a huge discussion. This is oft litigated, right? It depends on things like how much proprietary information is included in that customer list. Do people, lay people know who the potential customers are in this industry? Is it locked down? Is it password protected? Are employees prohibited from forwarding it or downloading it, et cetera, et cetera, et cetera? Very fact specific question, but we are often litigating the question of whether in a particular case a customer list is or is not a trade secret or confidential.
Well, that's great. I think we ought to wrap it there. Caleb, a final comment for the audience?
Update those handbooks. It's the time of the year. I can't stress that enough. We do that typically at the end of the year. Involves a lot of handbooks being updated for us, and it's very important for employers. And that's the one thing that we can control. We can control our policies. We can't necessarily control the actions of every individual in the company. So please update those handbooks.
Kevin, parting comment.
I couldn't agree more with Caleb and Krista and you, Mark. Thank you so much, everybody, for attending.
And Krista.
Just thanks
Say
for
good night.
attending.
Thank you, everyone.
Thank you
All right.
all for attending. Please watch for the newsletter that will be coming out. Please complete the survey. Thank you for attending and being attentive. And keep looking for future webinars by our Foley and Lardner Labor and Employment Practice Group. Thank you very much for attending and have a good day.
Bye.